Welcome to our second panel. We have a great paper entitled Myra Bradwell and the Chicago Legal News, Speech and the March for All Civil Rights. Our author is Anastasia Bowden, who is a civil rights attorney at the Pacific Legal Foundation, where she focuses on economic opportunity and equality before the law. She's represented entrepreneurs and small businesses in challenges to various onerous licensing laws, anti-competitive titling restrictions, certificate of need programs, and other unnecessary impediments to people pursuing their chosen professions. Obviously a topic of relevance to her paper. We have two fantastic commentators to give us different perspectives on the paper. We have Ellen Du Bois, who is a distinguished research professor at the Myra and Renee Luskin Department of History at UCLA. She's the author of numerous academic articles addressing topics such as the political history of women in the US, the history of the women's suffrage movement in the US, and histories of American and international feminism. And finally, we have Nadine Strawson, who is the John Marshall Harlan II Professor of Law Emerita at New York Law School. She served as the president of the American Civil Liberties Union from 1991 to 2008 and is currently a senior fellow with the Foundation for Individual Rights and Education. She is a leading expert and intellectual warrior on behalf of freedom of speech and civil liberties. Her contributions on that front are far too numerous to mention. So we are going to start by having Anastasia introduce her paper.
Great. Well, thanks so much for having me. It's a pleasure to be here and an honor to be next to such esteemed co-panelists. To introduce my paper, my interest in this topic comes from a really practical angle, and that's that I'm a practicing constitutional attorney, mostly specializing in economic liberty cases, so representing small businesses, would-be entrepreneurs who have been essentially shut out of their occupation, prevented from putting food on the table by what I think most people would characterize as overly onerous and sometimes explicitly anti-competitive regulations. And those cases, I've challenged some pretty ridiculous laws in my life, and those cases are still very difficult to win, almost impossible to win, because courts give very little protection to the right to earn a living. But I've also litigated First Amendment cases, and in fact, I've litigated a lot of First Amendment cases with an economic liberty theme, so cases where the person's profession is speech. Or cases where there's an economic regulation we're challenging that affects speech, but it's truly an economic regulation. It's harming those people from earning a living. So self-titling, people want to call themselves, let's say, an interior designer, but the state says you can't do that with some sort of specialized license. I think that's truly an economic liberty case, but it arises in a First Amendment context. And the point is, when you walk into court asserting a First Amendment claim, those cases are much easier to win because courts care very much about the First Amendment compared to the 14th Amendment, and in particular, unenumerated rights like the right to earn a living. I think that's a very frustrating distinction for me when I see these people and their claims get shoveled into economic liberty claims and they get zero protection. But if you're clever enough to kind of come up with some First Amendment angle, then you get a lot of protection, when in reality I think these things are not easily distinguishable. I mean, economic liberty is very much the other side of the coin of free speech in a lot of instances because speech is a profession. I mean, being a lawyer entails a lot of speech, a lot of writing, a lot of argumentation, a lot of, frankly, creativity. And so I think that it's not easy to distinguish these rights, and yet they get such disparate treatment in the courts. And Myra Bradwell's life really illustrates that very nicely. She goes to court seeking her right to earn a living. She wants to be an attorney. She's told that she can't. She has no constitutional right to do that. But she retains her right to free speech. And through that, she's able to, very ironically, earn a living. Speech becomes her profession. And she's also able to advocate for equality before the law, for property rights, for all sorts of rights. She ends up freeing Abraham Lincoln's wife, his widow, Mary Todd Lincoln, from an insane asylum, all through the power of speech, through her newspaper that she establishes, through agitating the press and the legislature. And I think it again, just illustrates how all these rights are actually one thing, and it doesn't make a whole lot of sense to try to start describing what particular right is at issue. What's at issue is liberty. And certainly the First Amendment is a prerequisite to the exercise of a lot of these rights in her life, but sometimes economic rights were a prerequisite to her even exercising her First Amendment right. And so again, these things are all intertwined. So I just want to talk a little bit about my paper and Myra's life, most importantly, and how that brings out that theme. And that is, she goes to court again. She's denied her right to be an attorney, so she starts up the Chicago Legal News. And it's really amazing what an entrepreneur she was. Within months, she's able to secure a contract with the state of Illinois, which says that she can print the statutes before the end of the term, such that lawyers no longer have to wait months at that time to get access to these statutes because the Secretary of State was taking so long to print them. And so she becomes invaluable to lawyers. She also secures a court rule that says that if a legal decision appears in her newspaper, that is evidence in court of that law's existence and what it says. So her Chicago Legal News becomes actual evidence in court. Again, that's indispensable to lawyers, and they start subscribing to her magazine. She later expands into the printing business, into book binding. She ends up, again, the irony, drafting templates that are for wills or bankruptcy documents. So legal templates. She's effectively acting as a lawyer through this First Amendment right to publish in a magazine. She becomes what lawyers would say is above the law, Westlaw, and Cockle in one, because she's also through this newspaper including very witty commentary, biting commentary, social commentary on the state of the times and the way that women are treated in equal rights. So she uses this newspaper to become very successful, to advocate for change. She gets many laws changed. She gets the Married Women's Earning Act passed. She gets the Married Women's Property Statute, a law giving mothers equal custodial rights as fathers. Countless reforms in the profession, the legal profession. Even though she's been excluded from the legal profession, here she is at its outskirts, making sure that judges are paid better in order to make sure that the quality was really there, because there were some issues with the legal system at the time. She encourages investigation of juror bribery, improving judicial facilities, reducing waste in the judiciary and in the Illinois Supreme Court. That, again, as I was alluding to, she uses this free speech power to free Mary Todd Lincoln from an insane asylum. And it's a story that I had never heard of. I think most people have never heard of. I mean, I think we all, maybe this is just me, but growing up, you kind of hear this allusion to the fact of Mary Todd Lincoln being a little off, maybe a little crazy. Here, I did not know that actually there's been a whole book published that goes to show, in fact, maybe that narrative is not correct. She was eccentric, sure. She may have had mild depression, sure. But was she insane? I don't think so. When you look at this evidence and the way that she ended up being committed, a dozen due process violations. She wasn't even able to mount her own defense effectively. But also, there's some evidence that Robert Lincoln just didn't like her spending habits, and it was his inheritance issue, and that was his motivation to get her into an insane asylum. And at the time, it was very easy to call women crazy and to get them committed against their will. And that story hasn't been told, again, because of the absence of speech. For a really long time, there was no book about Mary Todd Lincoln offering her side of the story. Instead, there were many biographies about Abraham Lincoln. And actually, through the help of Myra Bradwell and her descendants and them saving some of her papers, this story on behalf of Mary Todd Lincoln starts to come out. It's all a very, again, interesting meta theme of speech and what happens when we don't have speech. You don't have the other side of the story. You're not able to have this debate. And even to this day, there are historians who think that, in fact, Robert Todd Lincoln was justified in what he did, and that she really was unwell. But at least now that we have both sides of the story, we can have that debate openly, and people can draw their own conclusions instead of only having one side of the story. There's one last theme I wanted to bring out about free speech in Myra's life, and that's why that's about how her story hasn't really been told that well, especially if you think about her story compared to the slaughterhouse cases, which is a much more famous case in constitutional law. It was decided the day before her case. It was the same issue, whether you have the right to earn a living under the Privileges or Immunities Clause. In that case, the court decided 5-4 that people do not have that right. The very next day, it's Myra's case, same exact issue. Do you have a right to earn a living? It's decided 8-1 against her. And that's really interesting. Why is that? How is it that 3 dissenting justices in effectively the same case with the same issues, they all switch? And that's because they basically say, in Myra's case, well, you're a woman and that's different. But there was one justice who was consistent across both cases, and that's the amazing Salmon P. Chase, Chief Justice Salmon P. Chase, who held that everyone has a right to earn a living under the Privileges or Immunities Clause, men and women alike, people of all races. Another fantastic person who really hasn't been appreciated enough, I think, in constitutional history. But in any event, he was too ill to write a dissent. And I think maybe that changed the course of history. The dissents in the slaughterhouse cases are very well known. They've become, I think, the prevailing viewpoint when it comes to the Privileges or Immunities Clause. Constitutional scholars across all spectrums of every viewpoint largely believe, whatever they think the Privileges or Immunities Clause means, they largely believe that that case was decided incorrectly. So the dissent has been vindicated in over time. With Myra, there was no dissent. There was no one to tell her story, to tell her legal theory. And I really do wonder if we had that dissent, whether we would have a better appreciation for her. So again, this theme of speech and the absence of speech and what are the consequences of that. And I think that's also nice, just dissent as an institution. It brings out what a lovely institution it is. This is the losing side, but one, it's a model of civil debate, civility, even with deeply disagreeing people. It brings out the weaknesses, the majority's opinion. Ruth Bader Ginsburg always said that Scalia's very biting dissents made her opinions better, right? So there's value to it on both sides. You can debate facts, and again, you can persuade people over time. And so when we don't have this speech, this dissent, I think we do a disservice not only to the people involved, but to all of us, because we don't have an opportunity to read that. So in sum, I guess I would say, Myra lost in the Supreme Court because she asserted her right to earn a living, but she won in the court of history by exercising her First Amendment right. And all throughout her life, speech was a prerequisite to other rights, very important rights that allowed her to thrive and allowed others to thrive, because she secured civil rights for many people through her exercise of that speech. And ironically, it allowed her to effectively become a lawyer without any court's dispensation. I think that's a really lovely note to take away about free speech and its importance in our society.
Great, thank you very much. Ellen?
Okay. Sorry. Thank you, Anastasia. I'm going to deal with this as a women's rights issue, and I think Nadine can correct me if I'm wrong. It may have been one of the first women's rights cases to come before the Supreme Court. And also, let me be specific about the historical context. It's right in the middle of Reconstruction. The ink on the 14th Amendment isn't dry, okay? And also, if I look more carefully, I would have seen the relationship between your work and this case, and it would have helped me to understand how you framed it. First of all, by the way, I don't think she was forbidden to be a lawyer. She was kept out of the bar. And, to be a lawyer, who knew? If you read law with a lawyer, you were educated in the law. The question is, are you admitted to the bar? And that's what the case was. The Illinois bar prohibited her. Her case, because she was, she brought the case before the U.S. Supreme Court, but of course it had to be argued by a man, Matthew Carpenter, a senator from Wisconsin. There was, I think, no argument. It's not just that Chase didn't publish his refutation. I think there was no argument before the court against against Carpenter's position. In other words, it was almost so obvious that no one had to argue it, and by obvious I mean women. A point here, by the way, I learned by doing this that Congress had just enlarged the court for the 7th and last time to a number 9. Also, I believe Salmon Chase was the only Supreme Court justice ever impeached. Do I have it wrong?
I think you're right.
Okay. He wasn't
Not
removed, but he was
yes.
impeached. 8 years after Myra's case came before was decided, a Washington, D.C. lawyer named Belva Lockwood, who may be more well known here than in other places, became the first woman to argue before the court. Anastasia enlarges the story beyond this 1873 moment. And I found, of course, the Mary Todd Lincoln story really interesting. I went looking. My understanding is that the book that first brought this out was put together by her granddaughter or her great-granddaughter. Somehow, through the women in this family, they paid attention to getting these letters out, which is what the book was about. My contribution is twofold. I want to summarize the constitutional issues on which her case was decided, which were not free speech issues. I also want to link this case to another episode, and that is the beginning of the Comstock Law, which occurs at just the exact same time, and of course is an explicitly free speech issue. The case was argued differently when it was argued in Illinois, but when it went before the court, it was a 14th Amendment case. And the argument was twofold. The resistance to the argument was twofold. One is that the 14th Amendment did not add any new citizenship rights. And secondly, that it did not establish the supremacy of federal over state law. These, of course, were the crucial issues in 14th Amendment litigation. As Anastasia says, it came after the slaughterhouse. It was decided the day after the slaughterhouse. That may have been why there was so little. This happened again a few years later in the Minor case, where there is very little elaboration of the case, because, who needs to have it elaborated that women don't have the same rights as men? Now, legal history tends to cite a concurring, when you read about this, I'm not sure in law books, but in history books, it's explained by reference to a concurring opinion by Justice Bradley, who just happened to be the 9th Justice who had just been appointed. And he had completely ignored all the legal arguments, and instead he talked about how women were, that men were the natural protectors of women, and women had a natural timidity and delicacy which rendered them unsuitable for professions, including the law. By the way, let me point out that if you compare law and medicine, there were tons of women who were medical doctors in the 19th century, and very few women who practiced law. Of course, an entire movement was based on understanding the law. That was the women's suffrage movement. The women's suffrage movement had already laid out an innovative and ambitious constitutional argument that was connected to Myra Bradwell, that because of the 14th Amendment, women were persons, and as persons they were citizens, and with neither of those did the court ever object. But the final point was that as citizens and having national citizenship rights, clearly they could vote. What else is a right of citizenship than the right to vote? And that, of course, was denied by the court. If the court had accepted that argument, that the right to vote was inherent in the rights and privileges of national citizenships, the whole history of the United States would be different. That's a little excessive, but of course, the right to vote is still protected under state law and is not a national right. Under the same argument, the most famous person to argue this is all completely simultaneous with Bradwell, was Susan B. Anthony, who was she was allowed to vote, and then she was actually arrested on grounds of illegal voting, which I think is actually part of the 14th Amendment. And it's a very famous case, but the judge, who was a Supreme Court judge who was sitting circuit in New York, did various things. Particularly, when she wouldn't pay the fine, he didn't imprison her, so she couldn't appeal the court on habeas corpus, so she was heartbroken. But the person who brought the case was a woman named Virginia Minor, and that's a few years later, and once again, it's completely simultaneous with other cases dealing with civil and political rights. It anticipates and is connected with Reese and Cruikshank. So my point here is that women's rights and citizens' rights and human rights are not just abstractly linked, but in these legal environments, they are explicitly linked. You can't really make a case for women's rights without making the larger case. Very quickly, let me just say that these years were dense with consequential and constitutional developments. Exactly simultaneous with Bradwell was the emergence of Anthony Comstock and what were called the Comstock laws, which were both state and a federal law. The federal law, which is the one we know about, is that you can't. The way you could use federal law was to say you can't use the males to cross state lines with any article or thing designed or intended for the prevention of contraception and procuring an abortion, and also for lascivious intents. So I'm not going to go over this in detail. I know I've run over my time, but the Comstock laws are explicitly about free speech. They have always been brought in one way or another, either against left-wing radicals or women who are pushing for women's rights. And the crucial decision that finally begins to undo Comstock is a case brought by Margaret Sanger a half century after these laws are established. And subsequent to that, I think there were decisions, I think it's the Sanger decision, that said you can't use these laws, that if they have medical purposes, the lasciviousness, it does not apply. And it seems to me, and it's at that point that Comstock becomes a zombie law, or what's the legal word, desuetude?
Oh, right.
Desuetude. I have a feeling if this it seems to me if this history were better known, then anti-abortion people would not be as likely to hold Comstock as a tool, a living tool, for the purposes of prohibiting medical abortion materials to be sent across state lines. Thank you, and I'm sorry it took so long.
Okay, thank you. Nadine?
Well, many thanks to Anastasia for a brilliant paper and to Ellen for a brilliant commentary. I'm going to weigh in using my expertise as a free speech champion. I'm going to situate the importance of the paper in a larger context about current challenges to free speech. And Ellen, I really loved how you drew on your unique expertise in terms of women's history to underscore the importance of the paper from that perspective. But first, a fun fact. when I was doing research into my esteemed co-panelists. Anastasia, I saw in your bio that you and I have something interesting in common. We were both shortlisted by on a list of potential Supreme Court nominees by a presidential candidate. But before you get too excited, it was a candidate that probably most of you have not heard of, Jo Jorgensen, who was running on the Libertarian Party ticket. But she listed us among some pro-liberty potential Supreme Court justices. So I think that what I really love about this paper is that it is such a fantastic illustration of the multifaceted reinforcing relationship between free speech and other human rights, including equal rights, including women's rights, even to the point that you say that these rights are really indistinguishable. It's kind of artificial to separate them out. This paper is an important corrective to a very pervasive assumption that we have to choose between women's equality on the one hand, women's dignity, women's safety, which is certainly very, very important goals. I doubt that anybody would disagree with that. But we have to choose between that set of women-centered, equality-centered goals on the one hand, and any other right on the other hand, not only free speech, but also due process. This was a major debate during the heyday of the Me Too movement when it had reached its crescendo a few years ago. Jeff Rosen, who is the president and CEO of the National Constitution Center, as well as a law professor at GW Law School, interviewed Ruth Bader Ginsburg at that point, shortly before her death. And he said, you know, people are debating about due process concerns in the context of the Me Too movement. How do you accommodate between or balance or weigh the competing concerns of women's equality on the one hand and due process on the other hand? And Ginsburg, who I should stress, started her illustrious career as an advocate of women's rights at the ACLU as the founding director of our Women's Rights Project. She, without hesitation, said, you don't choose, you have both. You need due process to advance women's rights. And by the way, and this really ties into the larger theme here that I see your paper being so important to illustrate, is the reason that Ginsburg gave, for a major reason that she gave for choosing to locate her advocacy and her litigation in advancing women's rights at the ACLU in particular. She was asked why this organization that, you know, is so well known for free speech and other rights, why not go to the National Organization for Women or other groups that focus specifically on women's rights. And she said that strategically and educationally, and as a matter of understanding the right at issue, it had to be situated within an overall general agenda of all human rights, all fundamental rights for all people. And Ginsburg, I was thinking of some of her famous lines, why you actually quote some of her lines in your paper, Anastasia, but also during Ellen's comments, that laws that were seen as benefiting women, we now look back on and say that was paternalistic. You may have had a positive intent, maybe not, but the impact was certainly to treat women without question. As you said, Ellen, it was just so taken for granted that a rationale didn't even have to be articulated. And what's troubling to me is to see the constant reoccurrence of these same arguments, these same supposed dichotomies coming from the left and the progressive left in the name of advancing women's equality, as well as, to be sure, as well as coming from the right, because as Ellen alluded to, the Comstock laws, which have never been completely repealed have recently been resuscitated and wielded by not only Republican members of Congress, but also a conservative federal judge in the service of restrictions on access to medical abortion. So I think it would really be so important to use this paper as an example of how those of us who are committed to women's rights all across the ideological spectrum really have a stake in defending free speech, including for speech that is attacked as being anti-women. Now, recently, and this is, I assume this is why I was asked to be on this panel, because I have spent decades now in the position of liberal feminism, and I use that in the sense of classical liberal, although I'm also a political liberal, opposing so-called radical feminists who have sought to suppress expression that they label pornography, or lately it's been labeled sexual harassment, other stigmatizing terms, on the rationale that this is expression that undermines women's rights, women's safety, women's dignity, and women's equality. And so in 1995, a book that I wrote on this topic called Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights was published. I raised this only because last year NYU Press came to me and said these issues are recurring. We are seeing repeated and renewed assaults on sexual expression using that stigmatizing term pornography. It's again coming from across the political spectrum. Sometimes it's the right that's focusing on LGBTQ sexuality or reproductive rights. Sometimes it's coming from the left and focusing on revenge porn and sexual harassment. But can we republish this book as part of the NYU Classics series? So I think there was recently a book that was authored by Marianne Franks that is again offering a so-called radical feminist perspective on free speech and how damaging it allegedly has been to women. I had printed out a little excerpt, but I'm probably running over time. But let me just read you a little excerpt from her conception. This is a book that's getting quite a bit of attention.
Rename the book, please.
Yeah, I'm so sorry, I can't remember the name of the book, but her name is Marianne Franks, and I think it's got the words brave speech in the title. I'm very bad at titles in general. That's not I had to look up the title of my own book, so that's not a condemnation of Marianne's book. But fearless speech. Okay, so here's a description. First of all, I had written an article with another ACLU leader explaining why we believed that the ACLU's defense of free speech, including for sexually explicit speech and other controversial speech, was actually beneficial to women, same point that had been made by the Women's Rights Project. And she counters by listing the kinds of expression that have resulted from ACLU and other defense, more importantly Supreme Court enforcement of free speech in terms of the negative impacts on women. And she refers to stalking, sexual harassment, rape threats, non-consensual pornography, doxing, and deep fake porn. Now, in fairness, Marianne goes on to say that these kinds of expressions silence women as a group, and she says we have to ask the question, how much of women's art, literature, teaching, and leadership have we lost because of misogynistic abuse, and says we have to ask that question. I agree with her. We have to ask that question. But on the other side, I think she and those who come down in favor of constricting free speech don't ask another at least as essential question, which is how have women benefited by free speech? And I think that your paper, Anastasia, is a wonderful contribution to what I hope will be a more flourishing exploration and a more systematic exploration of how essential free speech has been for advancing women's rights in particular. I don't know if I have any more time at all. If I have, no? Okay.
No, you're fine.
Okay. I do also want to weigh in on this, another dichotomy. So dichotomies are, I was going to say, are always oversimplified, but maybe that's an oversimplification. So, the dichotomy between equal rights for women and free speech, but between so-called personal rights and so-called property rights. And usually that's a point that tends to be made by people on the right or libertarian end of the ideological spectrum, but some very respected liberals have made that point as well. And one of my favorites was Justice William O. Douglas, who said, what's this distinction between property rights and personal rights or individual rights? He said, people have rights, and some of their rights relate to property, and some relate to what we would call liberty. And what particularly flummoxes me about the slaughterhouse cases and the truncated misinterpretation of the 14th Amendment is that if there was any animating force, historical force behind the 14th Amendment, it was opposition to slavery. And what the essence of enslavement is both a complete deprivation of liberty and humanity and not being allowed to work for and to retain the fruits of your own labor. They're completely indistinguishable from each other. So again, many thanks. I'm definitely going to be continuing to cite your paper, including in ongoing discussions I look forward to with Marianne Franks.
Great, thank you all. That was a great introduction to the paper. I have so many questions. I think this is a fascinating paper on many levels. Let me try one, which I think is from a historical perspective. It's fascinating to me that your paper documents you have this woman who was denied entry to a profession and managed to simply parlay her free speech rights, you might say, her free speech into achieving a position of influence over the law that probably outstripped the vast majority of bar members, right, in her career. And it occurred to me to wonder, the 19th century was not characterized by robust judicial protection of free speech rights. And so you could imagine a version of this story in which the same societal and institutional forces that didn't want to let her be a lawyer suppressed her speech as well. You could imagine the Comstock laws having been used against her newspaper because she was agitating for women's rights, perhaps, or something like that. And I'm wondering, why do we think that didn't happen?
Yeah, that's an interesting hypothetical. I think, she was just able very early on to parlay her speech rights, her ability to start this company into vast influence. She really did have a lot of influence in Illinois that other people didn't. She was very well known, especially in local politics. Her husband was at one point a politician. And so it might just be that, it's a lovely thing. I think that the law wouldn't have been able to defeat her anyway because she held so much clout and was able to go straight to the legislature and get what she wanted. Even to start that business, the Chicago Legal News, she actually was prohibited by law from doing that, and she went straight to the legislature and she got a special exemption that would a charter that would allow her to do it, because at the time, if you were a married woman, you couldn't form contracts, and of course, forming a contract is very central to starting a business, and so she just went and got a special exemption. She would not be dominated, and so that might be it. But I think even so, relatively speaking, I know free speech has had challenges, like many rights have throughout history, but relative to economic liberty, it's had it better in courts than property rights or the right to contract. So who knows which way it would have gone. I would like to add to that. First, thank you so much for both of your very kind and generous comments, and for reminding me that we were on the short list together. I had remembered that because I saw your name and thought, wow, I get to be next to Nadine Strawson. You probably read it and thought, who's this Anastasia Bowden? but yes, I'm very grateful, especially because I did come at this paper. I'm not a historian, and while I have practiced First Amendment cases, I'm by no means a First Amendment expert. I come at this from a very practical perspective as a mainly economic liberty lawyer concerned with the real world consequences of trying to divide these rights, and a very ongoing and lively debate within constitutional law about how do we define which rights are protected by the Constitution, what level of scrutiny do we give these different rights, and what is the meaning of the Privileges or Immunities Clause if the court was wrong in Bradwell and Slaughterhouse. So I'm just grateful to have the very important context and for your remarks.
Well, a couple things. First of all, I guess to reinforce what I said about, you could train, you weren't trained at law schools, that the practice of law was very general, and I think we should, which is different than being admitted to the bar. And I think we should realize that basically the entire women's rights movement, or most of it, was a movement about law. Certainly Elizabeth Cady Stanton was one of the most well-educated in law. She basically apprenticed with her father, but she never went before court. It was for making cases, such as this very interesting argument that the 14th Amendment grants national protection to suffrage. That was an argument that came out of the suffrage movement and had enormous constitutional protections. To sort of complement this on the other side, the notion that women couldn't form contracts was based on a legal principle that predates written law, and it's the Anglo-American principle of coverture, which was never, I don't think it was explicitly incorporated in law, I might be wrong, but it was taking apart this law and this principle and its consequences, that once, it wasn't about women, it was about married women. Once women were married, they lost any individual rights. And this, in some ways, was the absolutely indispensable opening salvo for women's rights. Just one other thing about Comstock. To my knowledge, Comstock was always used against what we would call people on the left, people pushing for radical sexual ideas, in which the notion of contraception and birth control were included. I don't believe they were ever used against what one might say right-wing laws or right-wing positions. Comstock was always explicitly about people who were pushing the edges of allowable speech on sexuality.
And it was done on the, I'm sorry, go ahead.
Oh, I'm sorry. One of the many interesting points in your paper, Anastasia, was that an argument that was made against women appearing in court specifically was that jurors and presumably others in the judicial system would be so distracted by the feminine charms that they would not be able to do justice. And one of the things I loved about the Myra quotes you had was how witty she was. She had such great wit and humor and satire in responding to these arguments, saying, well, if jurors are not, male jurors are not deciding based on the evidence and the law, maybe we have to replace the male jurors. But somewhat, amazingly similar arguments persisted well into the second half of the 20th century. As late as the early 1960s, the Supreme Court upheld or rejected a constitutional challenge to a law that essentially eliminated women from jury pools. They were not completely excluded, but they had to make extraordinary applications in order to be included. They weren't automatically included. And one of the rationales that was given, the court didn't explicitly refer to this, but it was in the pleadings and other background information, was the harm form so with the protectionist, paternalistic rationale, that women would be exposed on the jury to descriptions and depictions of crime and violence and criminal cases. So it's for women's own good. And again, that of course overlaps with free speech concerns, not to mention profound equality concerns, because the freedom of speech is the right to receive information and ideas as well as to convey them.
Yeah, I'd love to pick up on that theme because you had brought it up in your remarks about paternalism and how these laws that deprive women of dignity, I think, and equality, they're almost always cloaked as in paternalism and as some form of a compliment. Like even this idea that, well, women can't be lawyers because the people will be distracted. That's supposed to be a compliment, right? The people who say this, they think it's a compliment. And that's been something that's persisted through history and continues to this day. I mean, even with one of my favorite briefs from the ACLU, RBG's brief in the case having to do with women being given a higher drinking age than men. Mm-hmm. And RBG writes this brief on behalf of the ACLU saying that this is meant to be a compliment because the court trots out all these statistics. Well, women are better drivers and they're more responsible and they drink less and they commit fewer crimes. So of course they should get a higher drinking age. And she says, what is at one point in history seen as gallantry, often in hindsight, is Victorian condescension. She did not take that as a compliment. She said this renders women as men's quiescent companions, that we're just out in the background not drinking, we're wallflowers at the party, and it's the men are the rowdy ones, and that's why we should get a higher drinking age. And that persists, and it's in all sorts of cases. Again, it's First Amendment cases, it's this drinking age case. It's also in economic cases. I mean, even in my own practice, I had challenged a woman quota for publicly held companies in California. So just corporations were forced to have a minimum number of women. And the reason, the state, in court, they argued to us there needs to be a minimum number of women because women are just frankly better at directing companies because they commit fewer crimes. They have a certain leadership style, a je ne sais quoi, that's just different. And they carry less debt. When they're on public boards, the companies carry less debt. And, in our responsive brief, we said, so what you're saying is women are penny pinchers, law-abiding. This is offensive, but they truly meant it as a compliment. And I think it's just really interesting that this theme of paternalism has persisted over time and even in economic context continues to be trotted out.
Or to put it more succinctly, I shall be women's protector whether or not they wish to be protected.
That sounds familiar.
All right, I think we should make sure that we have some time for if there are questions from the audience. I'm sure we could go on talking our whole time up here, but we want to give the audience a chance to participate. So,
I have a question for the audience, which is, do you think the Comstock Law can be used today as it is argued to be used, or is it dead?
Oh, no, I think Trump's probably going to enforce it.
Say it again?
I think Trump's probably going to enforce it, the Trump Justice Department. I think we're going to find out in, 3 months.
Whatever ways are convenient.
Getting back to Bradwell, frankly, I'm surprised the court granted cert in the Bradwell case, but since they did, that would have meant the oral argument occurred before the slaughterhouse decision came down, when the meaning of privileges and immunities was still in play. Do we have any idea what happened in the oral argument? Did any of the 4 dissenters in Slaughterhouse push back in Bradwell's favor?
I don't know. I will say another interesting factual tidbit that you reminded me of was that Illinois did not send opposing counsel because they thought it was so obvious that she did not have this right. So it was only Matthew Carpenter, and there were a series of consequences due to Myra being forced to have an attorney and she couldn't represent herself. One of which was he was very careful to make sure that his argument would not implicate the woman's right to vote, because he knew that maybe the court might accept a right to earn a living, but they would not go so far as to accept a right to vote. So he crafted his argument very narrowly and conscientiously said that, let's not even talk about the right to vote. And that created a lasting schism, or I don't know if it created it, but was part of a lasting schism, I think, between Susan B. Anthony and Myra Bradwell, because Susan B. Anthony was horrified by that argument that he just abandoned a really important thing for women's rights in service of this one case. Another thing that I think was interesting, and maybe Myra Bradwell would have done it differently if she was the one making her own argument. The other thing I just thought was kind of interesting was there was opposing counsel in the Slaughterhouse case, and who was opposing counsel? Matthew Carpenter. He argued the other side of Slaughterhouse, which is just fascinating to me that here he is arguing the other side of Slaughterhouse, and then he's taking on the other side of Myra's case. But in any event, I haven't read anything about oral argument. I don't know what happened. We just know that that 3 justices changed.
I have one comment. Both cases came before the court before the election, and this was the election of 1872, which determined the future of the Republican Party. It could have been eliminated at that point because of a schism. And the case is announced immediately, well, not after the election, but after the inauguration of Grant. So there's a really political timing involved in holding the decision.
Do we have anybody else from the audience? Okay, so I had another question that I'd love to hear this panel's view on, because, this is a great story about how freedom of speech and advancement of women's rights are, going hand in hand. And obviously there are people today who would argue that now we're at a place where sometimes claims made on behalf of free speech and civil liberties are perceived as impeding efforts to advance women. So I'll give you an example. Think of the case, the Roberts v. J.C.'s case, where what you have is on the one hand a private organization that they view their expressive purposes as requiring them to be an all-male organization. They're sued under basically a public accommodations law by a woman who wants to join. And so that's an interesting case that seems to pit at least one version of free speech against a version of advancement of the rights of women. And I'm curious, what do you think Myra Bradwell would have said about that case? What do you think about that case? How do you, I'm interested in everybody, and also particularly Nadine, about how do you thread that needle and reconcile those two opposing forces?
Do you want to start with Myra Bradwell?
Yeah, I mean, it's interesting. Myra Bradwell was a very large advocate of free speech explicitly. Part of that just being her own interest in being a publisher. There were a lot of harsh laws, libel laws and things at that time that she worked to reform. I like to think that especially having been a voice on the minority side, a side that had speech that was disfavored at the time, she would want all speech. I don't know. This is just me speculating. This is me projecting, probably. That she would want all speech to be heard, regardless of anybody's judgment about whether it was helping or hindering anyone, because we only know in the court of history, I think, really what's good and what's bad. It kind of gets developed over time, and what at one point is considered a terrible viewpoint for women in the long run can be shown to be beneficial. So anyway, I think she would have said that we shouldn't have judgment about whether speech is good or bad when deciding whether speech protections exist. But again, maybe that's just my own opinion.
Well, before I answer the legal question, I think I have to have a personal disclaimer that I was personally directly benefited by the Supreme Court ruling in the J.C.'s case, striking down the J.C.'s all-male policy, because for many years the United States J.C.'s had an award called the 10 Outstanding Young Men Award. And when they lost that case, they had to suddenly change it to the 10 Outstanding Young Persons Award. And I was one of the 3 non-male persons to receive that award the first year that it was given. But even before that, I thought that this decision was persuasive. As I recall, it was authored by Sandra Day O'Connor. Maybe I'm wrong.
Well, she concurred in it.
She concurred? Okay. So the court acknowledged that the freedom of association, First Amendment value, was a very important value. And the court distinguished in particular what the J.C.'s were advocating and resting their case on was what they called freedom of expressive association, that they were coming together in order to not only communicate with themselves, but also to convey certain ideas to the public. And the Supreme Court accepted that premise, but concluded that that expressive association function would not in any way be undermined by the inclusion of women in the organization. That the JCs had not shown that the message about community support and supporting people who were entrepreneurs and engaged in business, fairly general good government, good citizen type values would not in any way be undermined by including women. But on the other hand, that there was a compelling interest in terms of women's equal participation in the public sphere, in society, in their communities, to have access to this organization that was so important in terms of networking. And so, that's an interesting interconnection also of the economic interests of women as well as more general equal protection rights of women.
What about, the other fascinating piece about this paper that we've talked, less about is the Mary Todd Lincoln part, and this issue of, a civil rights issue of, how easy is it for people to civilly commit you? I'm curious, how do you see that piece of the, that piece of your paper fitting in with the rest of the themes? And is there a problem still today with gender bias in civil commitments? Is this an issue that anybody's focused on? I mean, the most recent example, high-profile example that comes to mind is the travails of Britney Spears, right?
Yeah.
I'm curious to know what you think about that, and, its status as a current civil rights issue and the gender aspect of it, and
Yeah, the way it fits in with the paper is that I think it's illustrating again some of this arbitrariness, because there were real due process. I see we have 1 minute left. There were real due process problems, but part of lack of due process is a lack of free speech. Like if you can't testify in court on your own behalf, if you can't form a defense, all these things you can classify it as due process, and people like to say due process is purely procedural. In fact, they despise substantive due process, right? Only procedural due process. Procedural due process has a free speech aspect too. Procedural due process has a substantive aspect inherent in itself, which again just gets into the arbitrariness of calling things one right or another. And then the other part, the way that it relates to the paper, is just the fact that story was not told until Myra's own descendants, they maintained all this paperwork and it came out through publication, and now we're able to have our own judgment, and how when there's no free speech, there's nobody who's able to have full access to the facts and come to their own decision about the truth, about whether Mary Todd Lincoln was insane or not. But in modern times, I'll just offer my own opinion about Britney Spears, which is, regardless, I do not speak on behalf of PLF. I speak on behalf of a concerned Britney Spears former fan. I do wonder, just personally, if it were a man exhibiting the same behavior, whether he would have been committed to the same sort of
How could he be admitted to the same behavior? It was about sexual excess. That was part of the claim. There is no such claim against men, sexual excess.
Quite a few years ago, a friend of mine who is an award-winning documentarian-style playwright, Emily Mann, wrote a play. I told you I'm bad on titles. I'm not going to remember the title. But about a famous case, or she made it a famous case of a woman in Wisconsin in the same period who was imprisoned involuntarily on bogus charges of mental illness. And I had the chance to do a talk back, so I did some research. And as you no doubt know, there is an enormous pattern of these laws being used in another way that directly implicates free speech for women who are dissenting from their husbands in terms of their political views, women who were raising views that were seen as antithetical to the prevailing social or religious or sexual mores in their communities.
Great. Well, I think we're out of time. Thank you very much. Let's thank our panel.